adults. They don't have the same education that you and I have. In most instances, at least in Birmingham, they don't come from the same backgrounds. We had a huge problem in making sure we were in compliance with the JJDPA, which is the Federal Juvenile Justice and Delinquency Prevention Act, primarily because we were incarcerating too many status offenders. And a status offender is a child who commits an offense that, if it were committed by an adult, would not be illegal, like minor in possession of alcohol, curfew violation, beyond control, running away, something like that. Big thing it did was twofold. Number one, define the difference between a child's attorney and a guardian ad litem, and made it less likely that a child is going to be incarcerated for non-criminal offense. Reduce the number of kids that we have locked up in custody right now. The key things to know about the guardian ad litem versus a juvenile defender is this. A juvenile defender is the child's attorney. They are directed by the child. They do what the child instructs them to do. Just like if you as an adult were arrested and you hired or were appointed a lawyer, that lawyer is there to represent you, and is essentially their job is to get you out of trouble. There is an attorney-client relationship. The guardian ad litem is what's called a best interest lawyer, and their job is to make a recommendation to the court and to be involved in the proceedings in a manner that they believe is in the best interest of the child. They are not directed by the child. As a matter of fact, their opinion may be totally opposite what the child asks for. And there is no attorney-client relationship, so theoretically, a guardian ad litem could be called on as a witness in the case. I like to think of them more as the child's attorney, the defender, represents the child, and the guardian ad litem is almost an arm of the court. In a lot of counties, judges were only appointing guardians ad litem. They were not appointing lawyers to represent the child in the child's interest, or defense lawyers. And you know, even guilty people are entitled to have defense lawyers. We have to keep in mind that I have the ability to incarcerate a kid until he's 21. And that's put him in jail. It's not like staying at the Winfrey or at the Ronald McDonald House. I mean, these places are jails that we put them in. And if you're going to deprive someone of their liberty in this country, you know, we get lawyers. That's what this country's based on. Probably the major provision of the Act as it relates to not incarcerating status offenders is the provision that limits the amount of time that a kid who violates an order under a status offense case or a CHINS case can be incarcerated. And it limits it to 72 hours in a 6-month period. Previously, if you came in on a CHINS case, an ungovernable case, I couldn't put you in jail immediately. But if I put you on probation and you violated probation, I could lock you up indefinitely. I could send you to the Department of Youth Services, which is obviously Alabama's juvenile prison system, or I could leave you locked up in the juvenile jail indefinitely. When you read in the JJ Act about juvenile detention, it is jail. And in jail, I have a kid right now in that juvenile jail charged as an adult with murder. That's probably the biggest provision that caused the biggest amount of turmoil among judges and among other people in the state. But what it did, it brought us closer to alignment with the JJDPA, which is important because we draw down federal funds from the federal government to help pay for some of these juvenile programs that we have in the state of Alabama. And if we're not in compliance, then we're not going to be able to draw down those federal dollars. The other thing we have to keep in mind is it costs a lot of money to lock up a kid. On average, it costs between $135 to $150 a day to lock up a kid in the state of Alabama, versus approximately $5 to $10 a day to have a kid on electronic monitoring. Is it really worth $150 a day to put a kid in jail? Is it right to have a kid locked up in jail for skipping school, for using bad language, for running away, locked up in jail in the same cell with people who are dealing drugs, who are convicted of rape, who are convicted of robbery, and who are convicted of murder? They need to be handled at home when possible. I mean, when I think about what I did, I was grounded. I got in trouble with my parents. If that doesn't work, is there some sort of child-parent conflict that can be handled via some sort of counseling? And if not, if that doesn't work, then some type of probation. As much as some judges probably wouldn't like to hear it, I think we fall short in our ability to incarcerate kids who haven't broken the law. I think we need to take away the judge's ability to lock up kids who don't break the law. And I think we need to go in and put some things in place that would encourage and allow judges to help police departments and help schools handle their school offenses internally. Because one thing that we see, especially in a lot of the metro areas in the state, we see a lot of kids being arrested from schools, and that's one thing that we've tried to target in Birmingham. I'd like to see some encouragement, some incentives that we can send back to the schools to handle those disciplinary matters internally, unless it's a serious offense. I mean, if the kid that was selling drugs at school, I need that kid in court. That kid needs to be in jail because he was selling drugs at school. The kid who skips class, the kid who tells his teacher, F you, that kid needs to be disciplined, but he probably doesn't need to be in jail with that drug dealer.
Community-based alternatives are extremely effective and cost-efficient. However, not enough money is in place to construct them. We would recommend presenting a cost-benefit analysis with the short-term and long-term effects of allotting more money to create them. Obviously, from a short-term perspective, the loss of money being put into the construction of community alternatives is unfortunate. The long-term effects, however, show much more cost-effective programs and much higher success rates. This new change in the system will not exclusively be carried out by state employees. It is going to require volunteers. It is going to be a community effort. Therefore, we recommend publicizing this need to the community and gathering as many volunteers as possible. In addition, we are concerned about the various instances in the Act where clarification is lacking. We recommend revising the Act in such a way that it will be a little bit clearer to those who are left to actually enforce these changes.